Richard Burgon.
Thank you, Madam Deputy Speaker, and I'd like to say what a pleasure it is to be responding for the opposition in this debate. And for our side, I'm following in the footsteps of a very learned gentleman, Baron Faulkner of Thurotton, and myself, though not quite so learned in my legal career. Before I was elected to represent my constituents, I was for 10 years a solicitor, a lawyer in my home city of Leeds. And in 8 years as an employment lawyer, I saw, like my honourable friend, the member for Ellesmere, Port and Neston, many changes to employment law. I was an employment lawyer angry at what the introduction of employment tribunal fees in 2011 has done to access to justice. And today, Madam Deputy Speaker, I'm here at the dispatch box to speak up for all those for whom access to justice has been deliberately obstructed by this government and the coalition government that preceded it. And I do want to share with honourable members present my memory of the first time I lodged an employment tribunal claim after the introduction of employment tribunal fees in 2011. I was shocked and saddened to see on the computer screen the following words appear. It said, "Customer, please enter your credit card details." And Madam Deputy Speaker, that did make me sick to my stomach, because are we saying that people attempting to assert their statutory rights, such as the statutory right to be paid the national minimum wage, the statutory right not to be discriminated against at work on grounds of gender, sexuality, religious belief or disability, are we saying that these people are reduced to being consumers or customers? I will not be giving way. There's limited time, and I want to give the Minister as much time as possible to answer. Are we saying that these people are reduced to being customers? In fact, they should be citizens. They should be viewed as citizens trying to assert their statutory rights and trying to seek justice. The honourable member is annoyed, not as annoyed as many are across the country who've seen their access to justice so unnecessarily restricted. And this report, Madam Deputy Speaker, which I commend, recommends that, to quote, "the overall quantum of fees charged for bringing cases to employment tribunals should be substantially reduced." And this report also recommends that, to quote, "the Ministry should introduce a system for regular re-rating of remission thresholds to take account of inflation." I think, Madam Deputy Speaker, and plenty of people outside this place do think we need to go further than that, and I will elaborate upon that in due course. But this report is to be commended. And today, Madam Deputy Speaker, we've heard excellent contributions from honourable members on both sides of the House, and I particularly welcome the contribution starting the debate from the honourable member for Bromley and Chislehurst, who is of course the chair of the Justice Select Committee, which, as he explained, unanimously supported this report. And I also want to just respond to a point raised by honourable friend, the member for Hammersmith and Fulham, and say that we do recognise the concerns of the campaign for freedom of information. And I would like to add to the comments and contributions made in this excellent debate today. How can it be disputed, after what we've heard today, that access to justice has been harmed, not helped, by this government and its coalition predecessor? Many of us in this place know of this from our own experience as MPs, with our constituency advice sessions overflowing with people who don't know where to turn when they can't access or afford legal advice or legal representation. Legal aid has been attacked. Employment tribunal fees have been introduced, and fees have been increased in divorce proceedings and in immigration and asylum cases. The fees that we are discussing today risk dissuading people from litigating at all, as my honourable friend, the member for St Helens, South and Wiston, explained earlier. And fees that we are discussing today have a discriminatory impact, as my honourable friend, the member for Brent Central, has indicated. The Select Committee is right to be concerned at the effect of court and tribunal fees on women in particular. The increase in the divorce petition fee from £410 to £500 disproportionately hits women, who are the vast majority of divorce petitioners. Why should the government be increasing what could be termed a divorce tax on people, including women who have suffered domestic violence or emotional abuse? And why is the government charging more, as has been explained today, for a divorce petition than it costs to process that divorce petition? Should the state really be making money from people's misery? And what have people bringing cases in the immigration and asylum chamber done? What have they done to deserve a proposed 600% increase? This is an attack on some of our society's most vulnerable people, those seeking asylum. And as we've heard in this place last week, it takes place against a backdrop of growing attacks on people who are perceived to be migrants. And let's turn to the committee's concerns in relation to employment tribunal fees. The committee quotes from the Odysseus Trust, which describes tribunal fees as a tax on justice imposed to enable HM Treasury to profit from people seeking to enforce their legal rights. And the same paragraph quotes the organisation Working Families, which says these fees imperil the rule of law. And this is also the view of legal experts, because the committee heard from Jonathan Smithers, the president of the Law Society, who said there is the possibility of a two-tier justice system for the rich and the poor. Any increase in fees will militate that rather than against it. And Chantal Amy Dorés, chair of the Bar Council, said our members who practice in the employment tribunals have very much formed the conclusion that the challenge at the moment is the level of fees in terms of access. And of course, Madam Deputy Speaker, the committee itself concluded that, and I hope that the whole House weighs these words from the committee very carefully, where there is conflict between the objectives of achieving cost recovery and preserving access to justice, the latter objective must prevail. Madam Deputy Speaker, I could not agree more. Employment tribunal fees have cut access to justice. As we've heard, there's been a 70% or so reduction in employment tribunal cases being brought. Cases for unauthorised deduction from wages are down by 56%. Cases for unfair dismissal are down by 72%. Cases for equal pay are down by 58%. And cases for sex discrimination are down by 68%. And cases for race discrimination are down by 60%. And as my honourable friend, the member for Delin, indicated so effectively earlier, is anybody seriously arguing that this drop in the number of claims being brought means that there's been a sudden Damascene conversion by all employers in the country and that somehow bad treatment has been abolished to the history books? Of course, that's not the case. It's just that claims aren't being brought. And we must remember the deterrent factor. The fact is that employment tribunal claims don't just help those who bring the employment tribunal claim. Employment tribunal claims also help those who never dream of bringing an employment tribunal claim, but it acts as a deterrent. The possibility of a claim being brought acts as a deterrent against employers engaging in bad and discriminatory behaviour. And the true nature of the remission system, Madam Deputy Speaker, must be discussed. And I remember when I was an employment lawyer helping people to fill in the remission fees and watching them do so, and the amount of humiliating detail they're expected to go into, providing so many bank statements and all their details. I remember getting documents back from the Employment Tribunal Service where they'd highlighted in yellow on the bank statement the fact that somebody had got £12 transferred into their bank account by a relative, and they were asked to explain what this money was for, where it had come from and why. And Unison was correct on remission to say that the system is not working. Unison argued that the Equality Impact Assessment of July 2012, prior to the introduction of fees, expected between 23.9% of claimants to benefit from full remission and 53% of claimants would benefit from a variable discount on fee rates up to £950. But the actual figures suggest that only 3.87% of claimants benefit from any remission. Madam Deputy Speaker, I think that's shocking. And it's with these statistics in mind that I welcome the Select Committee's criticism of the Ministry in failing to publish the review into the impact of employment tribunal fees. The committee has written, on the basis of evidence to us on the 9th of February, we assumed that the review would be published shortly. And they also said that we have not appreciated being strung along in this fashion. And they also said that it is, in their words, unacceptable to remain unpublished 6 months later. Who would not agree with that when ordinary people continue to miss out on justice? Therefore, Madam Deputy Speaker, we welcome that as well as the pressure brought to bear by this Select Committee report, we continue to see a legal challenge to employment tribunal fees by the trade union Unison, who have now taken their case to the Supreme Court, as my honourable friend, the member for Kingston upon Hull East, has mentioned earlier. I would like to say more, Madam Deputy Speaker, but I wish to give the Minister his opportunity to address some of those concerns that I and others have outlined today. So in conclusion, I wish to reiterate my support for the Select Committee's request that the Government publish its review into the impact of tribunal fees and that it reconsider its approach of treating court users as customers. Sir Hartley Shawcross, the Attorney General from 1945 to 51, when we had a fantastic government that changed things for the better, said in 1948 about the bill, the Legal Aid and Advice Bill, he said, "It is a bill which will open the doors of the courts freely to all persons who may wish to avail themselves of British justice without regard to the question of their wealth or ability to pay. Indeed, going back further to the time when Magna Carta decreed that to no one will we sell, deny or delay right or justice. It's an interesting historical reflection that our legal system, admirable though it is, has always been in many respects open to, and it has received grave criticisms on account of the fact that its benefits were only available to those who had purses sufficiently long to pay for them." Those were the words, Madam Deputy Speaker, of Hartley Shawcross, and I don't think anybody could put it better and advocate those principles more effectively. But regrettably, the principles outlined by Hartley Shawcross, those principles are up for debate again. This is an Estimates Day debate. I can make clear now, with no ifs and no buts, that a Labour government with the Right Honourable Member for Islington North as Prime Minister will abolish employment tribunal fees and pursue the principle of access to justice for all. It is an Estimates Day debate, and honourable members are aware that it is the convention usually not to vote on Estimates Day debates. However, let me make it clear, such is the strength of feeling amongst the Parliamentary Labour Party that this evening we will be voting against on the point of principle. Thank you very much, Madam Deputy Speaker.